Well, good evening and welcome to this evening's seminar entitled Delving into the Section 44 Toolbox. My name is Richard Sarll. I'm a barrister at 7 King's Bench Walk, and I'm a member of the London Shipping Law Centre Education Subcommittee. And as ever, we have a distinguished lineup of speakers and a very distinguished chair this evening. Mr. Justice Bright will be chairing, followed by Karen Maxwell at 20 Essex, Andrew Pearson of my chamber 7 KBW, followed by Tim Houghton of Nautica. This event is being given in collaboration with 7 King's Bench Walk. I'm really indebted to Karen for coming and speaking under our banner, and also you, Tim. We will nonetheless be providing the drinks afterwards. This event is being recorded. If you're asking questions, please do bear that in mind. People who are listening in, you can apparently send questions in and they'll appear on the computer before the speakers. We'll have questions at the end, so the presentation's first, questions at the end. This is a third of a series of seminars concerned with arbitration that the London Shipping Law Centre has recently put on. It's well known what caseload the LMAA has. It's much the envy of other institutions, with about 1,800 references a year, I think, according to the most recent statistics. And I'm sure there are many reasons for the widespread use of London arbitration in particular. But one reason in particular has to do with the availability of court powers to support arbitral proceedings. And I'm sure our distinguished speakers will take us through all those with great interest tonight. Last thing I have to say is to introduce Mr. Justice Bright, who doesn't really need much introduction. He was called to the bar in 1987. He practiced at 7 King's Bench Walk until he was appointed judge in the commercial courts in 2023. Just before he was made up as a judge, he was named by Lloyd's List in 2022 as Maritime Lawyer of the Year. And I therefore recommend him to you as an eminently suitable individual to chair tonight's seminars. So without any further ado, over to you, Robert.
Remembering to turn my microphone on before I start. So I'm Robert Bright. I'm delighted to be here and see so many familiar faces. I've been told that I have to introduce each of the speakers individually. I think this means I effectively have the father of the bride speech. I have to say flattering things, not embarrass people, and be vaguely amusing, which means making what my children call dad jokes. I've been told I should introduce everybody individually. I'm afraid I'm going to flout that instruction right from the beginning, because I really have the same thing to say about all of them. I was a barrister before I became a judge of the commercial court, as Richard had said, and I had the very distinct pleasure and privilege of working with all of them, as I did, in fact, with Richard. That naturally means I take credit for everything that they know and every valuable insight that they share with you. But above all, it means that I can tell you sincerely that they're not only very distinguished, knowledgeable, clever people, but also delightful, wonderful colleagues who I always enjoyed working with. I can remember absolutely nothing about almost every case I ever did, so I can't remember what the outcome was in any of them. So I'm just going to claim they were all great triumphs. And what I can say with some certainty is that on every occasion, each of these people produced excellent work product, which I then palmed off on the tribunal as my own with absolute shamelessness and always with great success. So Karen, I think, is starting off. Karen Maxwell from 20 Essex Street, who is every bit as wonderful as the two who come next.
Thank you. Can you hear me? Yes. Thank you, Robert. And can I start by thanking the LSLC and 7 KBW for inviting me to join the panel this evening. I'm sure we're going to have a very interesting discussion. I'm going to start with a bit of an overview of Section 44. I'm going to try and put it in a little bit of context, both in terms of the statutory framework and the historical context. I'm going to give you a quick reminder of the requirements under section 44 and make a few comments about those. And then to finish, I'm just going to touch on the possibility of alternative remedies from a tribunal or from an emergency arbitrator. So if we start by just stepping back a little bit and thinking about the framework of the 96 Act, and as always, the starting point is section 1, the general principles, and in particular, the principle that the court should intervene only in very limited circumstances, and its role is to support rather than supervise. And I think we can see in connection with section 44 in particular, that one of the aims of the Act was very much to rebalance the relationship between arbitration and court, effectively by limiting the court's role, sort of putting safety barriers on the exercise of its powers. I mean, just pausing there a moment, of course, there are some things that a court can do much more effectively than an arbitrator. So making orders against third parties, for example, and also imposing effective sanctions for breach of orders. Those would be good examples. But as always, the general starting point is that court intervention is very carefully limited. Now, the Act recognises that both the tribunal and the court can make interim orders of various types. Thinking first about the tribunal, there are the procedural powers in section 34. There are what's called general powers under section 38. I mean, they're called general, they're actually quite specific. They are powers to order security for costs, orders preserving property or evidence, or automated heckling, or orders relating to witness evidence. I think most importantly, for the purposes of tonight, we have section 39, the effect of which is that a tribunal can make a provisional award, so an interim award that's subject to adjustment, but only if the parties have agreed. On the other side of the line, we have section 44, which confers powers on the court. And just to note at the outset, it does apply to foreign seated arbitrations subject to the requirements of section 2. And it's also non-mandatory, so the parties could exclude it, but of course in practice that I think would be unheard of. So it's immediately clear that we do have an overlap here between the competence of the court and the tribunal. And I've given some examples on this slide, 2 specific powers that are conferred both on the tribunal and on the court under sections 38 and 44. I'm not going to say anything about those because I think Tim is going to cover those in his talk. But importantly, in the third bullet, we see that whenever an arbitration agreement or institutional rules confer a power to make a provisional order or award, you then have that sort of overlap. And as we'll see, section 44 has a number of safeguards which are designed to prevent the courts from overstepping. Just a couple of words on the historical context of section 44. There were 2 sources of inspiration for the section. The first is Article 9 of the Unsatral Model Law, which sets out just the general principle that going to a court for interim measures of protection is not regarded as incompatible with arbitration. So affirming the supportive role that a court can play. And secondly, the second source of inspiration, I suppose, is the previous arbitration legislation. And when you look at the list of powers in section 44(2), they are actually remarkably similar to the lists that were contained in the previous acts. The big changes that were introduced by section 44 was first of all the power to order security for costs of an arbitration and to make order for disclosure of documents, they were removed from the court and placed with the tribunal under sections 38 and 34. So a narrowing of the types of power that the court can exercise. And on top of that, a number of requirements that have to be satisfied before the court can make any order. And if you go back to the DAC report, you'll see there's some discussion of a case called Kenren, which some of us will remember. It was quite a notorious case at the time. It was the case in which the House of Lords upheld an order for security for costs in the context of an ICC arbitration. And the DAC make the point that this was really regarded with some dismay by members of the international arbitration community. And I think it's fair to say that the Act, the 96 Act, was seen as an opportunity to mend some of the damage to our reputation as an international arbitration jurisdiction by just rebalancing that relationship. So coming on to section 44 itself, I hope you can see that, it looks tiny on my screen. I'll just make a few points about the wording of the provision. The basic legislative technique is to copy over into the arbitration context the powers that the court would have in litigation. And we see in subsection 1, it's a non-mandatory provision. We also see that the powers exist for the purposes of and in relation to arbitral proceedings. Now, in some cases, there might be a jurisdictional dispute, so there might be an issue about whether the underlying claims actually fall within the arbitration agreement. And that issue is one that the court might end up determining on a section 44 application. There's some recent case law on this, a case called AT and Oil and Gas Authority. And the approach that the court takes is quite similar to in relation to section 9 stays. So it involves, I guess, a little bit of treading on arbitrators' toes, but it's quite a pragmatic response. And the court will determine the issue if it arises. Subsection 2 sets out the sorts of power that can be exercised. I think in practice, the one that's used most frequently is subparagraph E, interim injunctions, especially freezing injunctions. But there are, of course, other types of order that can be made. And I think Tim and Andrew are going to touch on some of those in due course. And then on top of that, subsections 3 to 5 overlay some additional requirements. I think it's fair to say that the wording of these provisions has given rise to some issues in practice, especially in relation to orders against third parties, but also in relation to the interplay with emergency arbitration. I'm not going to say anything about third parties because Tim is going to touch on that, but I will come on to emergency arbitration in a moment. So the section contemplates two types of situation. The first is an urgent case. If the case is urgent, then it falls within subsection 3, and the court can make an order for the purpose of preserving evidence or assets. Now, it's held at a really early stage that assets is given a broad meaning. So it includes a cause of action or a disputed contractual right. I think that there's still a little bit of a grey area around the question of whether it is always appropriate to grant a mandatory interim injunction requiring the performance of a disputed obligation, especially where that will effectively determine the underlying dispute. And there's been some recent case law on that. The sort of headline message from the courts is that they will proceed with caution. The other category is non-urgent cases. They fall within subsection 4, and the court can intervene either if the parties agree, well, that doesn't really happen very often, if at all, or if the tribunal gives permission for the application to be made. And I think that raises another sort of potentially grey area, and that is whether it's right for the tribunal to give its own view when giving permission, as to whether the interim order should be made. And again, there are some slightly conflicting dicta in some of the recent case law about that. I don't think it's been finally bottomed out yet. And then subsection 5 applies to all applications, and it says that the court can only act to the extent that the tribunal or any other body with power to act, it has no power or is unable to act effectively for the time being. And 2 points to make about that. The first is that in practice, this overlaps very substantially with the requirement of urgency under subsection 3. And if you think about it, the same sorts of factors are going to come into both those inquiries. And it was this actually that led the Law Commission to originally suggest that we should get rid of subsection 5 completely, because in fact, everything that it raises is subsumed under subsection 3, but it then backs off from that. So subsection 5 is staying. But the second point to make is that this provision has led to a bit of a debate in connection with emergency arbitration. And you might remember there was a case a while ago called Gerald Metals, which raised the question of whether the existence of the LCIA emergency arbitration mechanism might mean that it would be difficult to satisfy subsection 5. Again, that has never really finally been ruled on, so that issue is sort of there in the background. That brings me then to the final topic I was going to cover, which is just to briefly think about orders from the tribunal or from emergency arbitrators. As we all know, most institutions now provide an emergency arbitration mechanism, and actually many leading arbitration jurisdictions have enacted legislation providing a framework for EA, often including provisions for enforcement or appointment of emergency arbitrators. I thought it was quite interesting to compare how 2 London-based arbitration bodies approached this. In a sense, they're at different ends of the spectrum. So under the LMAA terms, there is no agreement entitling an arbitrator to make a provisional award, and there's no emergency arbitration mechanism. So in an LMAA case, you're always going to be going to court under section 44 for an interim order. By contrast, the LCIA rules have a range of options: expedited tribunal formation, emergency arbitration, and an express power to make provisional awards. So what do parties make of all this? Well, I think there is some anecdotal evidence that the availability of emergency arbitration is at least a factor in party choice. If you go back to the most recent Queen Mary survey, it was identified as one of the factors that parties would take into account when choosing a seat or an institution. But what we also know is that it appears that emergency arbitration is not used very often in practice. So the ICC have been doing some tracking of their cases, and it appears that applications for the appointment of an EA is made in less than 5% of cases. Currently tracking, I think, around 3%, and of course not all of those are granted. But I think what's interesting is that the take-up is particularly low in LCIA arbitration. So the most recent casework report tells us that in 2022, there were applications for the appointment of an emergency arbitrator in less than 1% of cases, and all those applications were refused. So no emergency arbitrator was appointed by the LCIA in 2022. And I guess that raises the question, why is there so little appetite for emergency arbitration in London seated arbitrations? And I think, as Richard mentioned at the outset, we can speculate and perhaps be quite confident that one key factor is the availability of remedies from the commercial court. So the judges have a huge amount of experience and expertise, It's an efficient system. It's quite easy to get hearings on at short notice. And in short, it's an excellent service that it would be very hard to compete with. And there's certainly no evidence to suggest that users of LMAA arbitration are clamouring for emergency arbitration. And just to wrap this up and thinking a little further, I think there are some obvious practical issues around getting effective orders from a tribunal or an EA. And I've identified some of them on this slide. The first one relates to timing. You will often need to apply at a very early stage before the tribunal's constituted very often. And even emergency arbitration can sometimes be too slow. And we're starting to see examples in the case law of parties having to apply under Section 44 pending an emergency arbitrator's decision. There are the usual due process concerns, and then some concerns around enforcement. First of all, the tribunal or EA can't bind a third party. And secondly, more generally, there are still, I think, some quite fundamental questions about whether a provisional award falls within the scope of the New York Convention. So I think pulling these threads together, these factors all go to explaining why, certainly in London maritime arbitration, emergency arbitration hasn't really taken off, and Section 44 does remain the preferred remedy. So I hope that's given you a bit of a background to Section 44 and a bit of context. I'm now going to hand over to Andrew.
Thanks very much. Is the microphone working? Good. So Karen has introduced the scheme of Section 44 of the Arbitration Act. And that means I can jump straight into the bit that I would like to focus on. And that's Section 44. I need to dib over the slides, don't I? Okay, Section 44(5), and the court's ability to grant injunctions, including my focus, freezing injunctions, and to appoint receivers in support of arbitral proceedings. And before I get into it, I'd like to conduct a little poll. Hands up anyone in the room who's obtained an interim freezing injunction. And hands up anyone who's obtained an order for receivership over goods or rights. A couple. The numbers don't surprise me. I think there were fewer hands up for freezers than there would be in a room full of commercial generalists, because shippers are often able to get security for claims by arrest or by a club LOU, and there were barely any for receivership orders because they are rare beasts. If after my 15 minutes you think of these supporting powers a little more often and have a broad idea of when they might be available, I'll be happy. First of all, I should set the scene. When seeking either of these orders in an arbitration context, the starting point is Section 44 of the Arbitration Act. Given that you've all come to a talk about Section 44, that's probably no surprise. Subsection 1 tells us that unless otherwise agreed, which it very rarely will be, at least in an LMAA context, the court has the same powers in relation to the matters below as it would in legal proceedings. So we're going to have to look at what the court can do when there's no arbitration involved. And subsection 5, part of the matters below, makes clear that injunctions and receivership orders are included in the court's supportive powers. What can the court do with freezing injunctions and receivership in a non-arbitration context? To find out the answer to that, we have to look at Section 37 of the Senior Courts Act 1981. It's on the screen. And as you can see, it's a very wide jurisdiction. Limitations have been put on parts of it by the case law. We'll need to think about them. We also need to remember that, as we saw in the previous slides, the power under Section 44 is only to order interim injunctions. So we need mentally to modify the text like I've done in the second block. That's the foundational jurisdiction, more or less. A little point here for those who are interested in legal history. Freezing injunctions are comparatively modern. They were first made in 1975 in a pair of shipping cases. Hooray for shipping law. The best known of which is the Moreva, which is one of those classic Denning judgments in which he makes some new law while suggesting that it was always so. If any of the junior lawyers in their room have heard their elders talking about Moreva injunctions, that is why. Receivership, by contrast, is so ancient that even the crustiest of practitioners don't remember it being called something else. It arose out of the Anglo-Norman law of mortgage. When a mortgagor defaulted, the old remedy was for the mortgagee to take possession of the land and use it to pay off the debt. But that was a pain in the neck, not least because it often led to claims that the mortgagor had mismanaged the land. And receivership was a way around the problem. It permitted the mortgagee to put someone in place, notionally as an agent for the mortgagor, to hold and manage the land and pay the interest due. And that is essentially still what a receiver does, holds and sometimes manages a particular asset or right. These days, it's not done as a notional agent, but as an officer of the court. So, what are the requirements for getting a freezing injunction? They were authoritatively summarized by the Privy Council in Convoy and Broad Idea. What you need to show is, first, a good arguable case. That's a low bar. You don't need to show that the claim is bound to succeed, or that it's strong enough to get summary judgment on, or even that it has a 50% chance of success. You need to show the existence of assets against which a judgment could be enforced, a real risk that if no freezing injunction is made, the respondent will dissipate the assets, and that the court should exercise its discretion in your favour. That's the just and convenient requirements. It used to be thought that you needed an existing cause of action, justiciable in England and Wales, against the respondent. The most interesting thing about Convoy and Broad Idea is that it says that's wrong, opening up the door to freestanding freezing injunction claims against third parties. That is perhaps more detail than we need at this stage. The important thing, for my purposes, is to think about the practical circumstances in which you might want to think about applying for a freezing injunction in support of a shipping arbitration. And I would suggest you ought to give it consideration, at least, when you have a shady counterparty and where the ordinary methods of getting security are not available. Let's take a look at the facts of an old case, the Siskina. The Siskina was, in the usual way, owned by a single ship company. She loaded cargo under freight prepaid bills of lading, which was meant to be delivered at Jeddah. In fact, the Siskina never made it anywhere near Jeddah. There was a dispute between the owners and the charterers. The owners ordered the Siskina not to transit the Suez Canal as she was meant to. Instead, she hung around at the near side of the canal while the owners and charterers argued about money that the owners said was due under the charter party. Charterers made some payments, plainly not enough for the owners' liking, because they ordered the Siskina to discharge her cargo in Cyprus, which she did. Now you can see why the cargo interests might have been rather annoyed about that. They'd prepaid their freight to have their cargo delivered, and it now wasn't going to be, all because of a fight between owners and charterers, which had nothing to do with them. Matters then took a turn for the even worse. Shortly after the only vessel owned by this one-ship company had discharged, she sank in Greek waters and was a total loss. The only asset left to the owners was a right to receive the insurance monies. Now, by this point, I hope you're all thinking that this sounds like a good shout to try and get a freezer on. Good arguable case, tick. Assets against which judgment could be enforced, the insurance monies, so tick. Real risk of dissipation, well, given shady behaviour in discharging in the wrong place, plus a mysterious sinking, tick. Just and convenient, tick. Ultimately, the injunction granted in the Siskina was discharged by the House of Lords. It held that there was no jurisdictional gateway under which service out could be made, but that's beside the point for present purposes. The point is that in circumstances like this, a freezer may be a real possibility. And indeed, it may be the best possibility. You can't arrest a vessel that's at the bottom of the Met. Another example, slightly less old this time, but only slightly, can be found in the facts of the Veracruz 1. The respondent was, again, a one-ship company, and they agreed to sell their vessel to the claimant. The respondents failed to meet the contractual delivery date, and in addition, the purchaser feared that there were defects in the vessel which wouldn't be put right in time for delivery. Now, this was not one of those cases where the purchaser wanted to get out of the contract. The purchaser intended to pay the contract price and take the vessel. But it had also commenced arbitration proceedings in which it claimed damages for late delivery and for the expected condition of the vessel. The claimant was understandably worried that when it paid over the purchase price, which was due in London on delivery, the respondent, which had no other assets, might pocket the purchase price and disappear. And this would cause real difficulties in trying to enforce an arbitral award. Again, you should by now thinking that this sounds like a good candidate for a freezing injunction. Good arguable case. Yes, at least in relation to the late delivery. Assets against which an award could be enforced. Yes, the purchase price. Real risk of dissipation. Well, yes, because there was nothing to prevent the respondent, a single ship company which no longer had a ship, from removing the assets from the jurisdiction. Just and convenient, yes. And again, a case in which no headway was going to be made using the well-worn arrest or club LOU routes. You're unlikely to achieve much by arresting a vessel which you yourself own, and there was no prospect of an LOU. When the respondents gave notice of their intention to deliver the vessel, the claimants did what you would hope. They sought and obtained a freezing injunction, restraining the respondents from dealing with the purchase price once it had been paid over. On appeal, the Court of Appeal upheld the freezing injunction that was made in respect of the late delivery. It set aside the injunction insofar as it related to the expected defects, because, so it held, the claimant didn't yet have any course of action in relation to those. And that was in accordance with the law as it stood then, but it would probably be decided differently today. Convoy and Broad Ideas shows that, amongst other things, it's not necessary to have a presently existing course of action in order to get a freezer. That was two old cases. Let's talk about the future. Tim is, I know, going to talk about the Law Commission's recommendation that relief under Section 44 should be available against third parties. I don't want to steal his thunder, so I'll just say this. There's a split in the authorities about whether Section 44 relief is available under the current law, and whatever the Law Commission might think, some commentators, in fact most commentators, think it's not. Let's assume that's going to change. What are the possibilities? The most important, as it seems to me, is that it will make Chabra injunctions available in support of arbitrations. What is a Chabra injunction? Well, it's a freezing injunction, but against a non-party. In court, it's available when there's good reason to believe that a third party is holding assets which in fact belong to the defendant. It's not difficult to imagine circumstances in which this could be extremely useful in the context in which we all work. Take this example. A one-ship company agrees to sell its vessel to a third party, which we can call the purchaser. After reaching agreement and signing the contract, the one-ship company gets a better offer from someone else. Let's call them the gazumper. It wants to get out of its original contract, and it doesn't much fancy paying over part of the higher purchase price as damages. The one-ship company structures its transaction like this. It sells the vessel to a related company for $1, and the related company then makes the sale to the gazumper. Net result, the gazumper has the vessel, the related company has the purchase price, and the one-ship company that originally owned the vessel has $1. Now, if you're the original purchaser in that situation, and your sale contract contains an arbitration clause, then on the law as it seems to stand, you're in trouble. Are you really going to bring an arbitration claim against a counterparty that has $1? If the law changes, however, you may find that you're in business. There might be a basis for looking past the $1 sale and saying that there's good reason to believe that the related party holds the purchase price for the original purchaser, so that it can be frozen using a Chabra injunction, and then you can get on with your arbitration. I'm sure you can come up with lots of other examples of the same sort of thing. All I will say is that this is potentially a very useful change in the law, or if the Law Commission's right, a helpful clarification of the law. Now I come on to the rare beast, receivership orders. The first question is what a receivership order actually is. It's an order that appoints an individual, independent of the parties, to receive and deal with specified assets in a certain way. And that may include managing the assets in question if they're the type of assets that require management. You may think that this is very similar to the power contained in Section 44, Section 44(2)(c) Roman 1 of the Arbitration Act, which empowers the court to make orders relating to property which is the subject of the proceedings, or as to which any question arises in the proceedings, and includes a power to make an order for the custody or detention of the property. And it is similar, but it's not the same. There are two key differences that I can see. The first is that the claimant doesn't need to have an interest in or right over the assets. It's not just property that's the subject of the proceedings, but any property. And the property is not dealt with by one of the parties in accordance with the court's order, but by a third party. The next question is what you need to show to get one. I've struggled to find a pithy catch-all statement beyond the one that's in section 37 of the Senior Courts Act itself. The power is to be exercised where it's just and convenient. The only real limitation on this is where the receivership order is in effect a stronger version of a freezing injunction, one that sees the receiver taking over the running of a company, for example, which is something that can be ordered using receivership. There, the freezing injunction test must be met, and there must be some reason why a freezer won't do the job. Sometimes it can be previous non-compliance with the terms of a freezing injunction. And for that, JSC, BTA Bank, and I always struggle with this name, Abliazov, is an example. But that's not the circumstance in which a receivership order is most likely to be useful to shipping practitioners, I don't think. It's most likely to be useful when something needs to be done and the respondent either can't or won't do it. Again, some examples. Once upon a time, there was a company called Metro Trading. Its business was the storage of oil products, and it did that by keeping them in large vessels anchored off Fujairah. It was also involved in oil trading. At some point in 1998, it was discovered that a large amount of oil that Metro Trading was supposed to be storing on behalf of third parties had gone missing. Metro Trading collapsed. Predictably enough, there was a mad rush by the companies whose oil was theoretically being stored. They all wanted to get their hands on what was left and say that was their bit. Now, I suppose it was probably the oil trading equivalent of a run on the banks, a disorderly scramble by all of them to make sure they weren't the one left with no oil at the end of the day. And that was a classic example of when it was just and convenient to appoint a receiver, and one was indeed appointed. The owners of the vessels holding the remaining oil were ordered to discharge it to the receiver, who was to sell it and get in the proceeds. And that would allow for an orderly distribution of what was left in accordance with whatever the courts decided. That's one example in which receivership is useful in a shipping context. Here's another. It's an unreported case about three vessels called the Morning Star, Silver Star, and Diamond Star. And I'd like to say thanks to Tim for bringing it to my attention. It's his case. In 2006, cargoes of rice were loaded on board three vessels, and they were all bound for Iraq. The vessels were subchartered to the Ministry of Trade and of the Republic of Iraq, which was also the FOB buyer of the rice. When the vessels got to Iraq, the Ministry of Trade rejected the cargoes in the first instance for reasons which I think remain somewhat mysterious, but which I assume had something to do with the Second Gulf War. They then asked for the cargo to be resampled, and then they just ignored it. They ignored the cargo, they ignored the vessels sitting off the Iraqi coast. It wasn't at all clear what ought to be done with the cargo. Couldn't be discharged because the Ministry of Trade was refusing to accept it. There was no obvious reason why it should be returned to the sellers, since they'd already been paid 95% of the purchase price. And it couldn't be kept on board the vessels indefinitely, partly because it would go bad, and partly because that would involve the vessel incurring detention charges of $28,000 a day. The disponent owner of the vessels, no doubt with more than half an eye on the fact that it was already owed quite a lot of days' worth of detention charges, applied to appoint a receiver. And that's what was done. The receiver was appointed to store the cargo while proceedings took place to decide what should happen to it. Again, receivership used as an orderly way of managing goods while litigation was ongoing. Now, it seems I'm running out of time, and that's a shame because otherwise I would lead you down my own personal memory lane to my first ever case. I was instructed in a fight about several reefers full of fish heads, if you can believe it, and they'd been left on a dock in Nigeria in the height of summer with the power turned off. I can only imagine how they smelled, and with hindsight, I think it probably was a case where a receiver would have made sense, but I was disinstructed and I never found out what happened. I'll wrap this up by suggesting to you that the possibilities of receivership are broad because the jurisdiction is so broad. While the cases I've mentioned relate to goods, it's also possible to appoint a receiver over a shows in action. I can see no reason, for instance, why it shouldn't be used to empower a receiver to give notification under an insurance policy, which is possessed by the counterparty, ensuring that it's properly triggered so that the proceeds can be got in. So those are my two particular areas, one fairly well known, one less so. Now I'll pass over to Tim, who'll speak more broadly about what you can, can't, and one day might be able to do with Section 44.
Thank you very much. Good evening. So yes, in the graveyard shift of this seminar, we're going to be looking at other uses of Section 44, some limitations on the use of Section 44, and tentatively some developments on Section 44. So broadly, some things you can do with Section 44, some things you can't do with Section 44, and maybe one day, once upon a time, you will be able to. So let's start, first of all, with things you can do. Well, Karen very helpfully took us through this earlier, but just subsection 1, the court has the power to make orders for the purposes of and in relation to arbitral proceedings about the matters listed in subsection 2. That little phrase in italics there will come back to a little later. Subsection 2, what are the matters about which the court can make an order? Well, the preservation of evidence is one thing we're going to be looking at now, but also making orders in relation to property which is the subject of proceedings or as to which any question arises in the proceedings. You can photograph it, you can inspect it, and you can even conduct an experiment on it. And finally, and the star of the show really, the granting of an interim injunction. And those are the three matters that we're going to focus on now. So let's just start with the preservation of evidence and the inspection of property which, as to which an issue arises in the proceedings. And Karen picked up on this really. It's the counterpart of that power in the section 44(2)(c you find in section 38(4) of the Act. So the arbitrators have got a very similar power there. Note the reference there to in the possession of a party to the proceedings. And you see it's the powers themselves exactly mirror what you see in the two subsections of 44(2)(c). So say you're the charterer or you're the cargo receiver, and you've got damaged cargo on board a ship, and you urgently need to take samples in order to work out what the extent of that damage is. Or typically, you're the charterer, the ship has suffered a breakdown, her engine is going to be repaired, but you want to get a surveyor on board pronto, because once the repairs are done, the evidence is lost, you'll never find out what went wrong. But let's also say that you've got a London arbitration clause in the normal way in the bill of lading or charge party, but there are no arbitrators appointed, and there just isn't time to get your tribunal constituted. Now, those situations, they may be suitable for what's often called a Vasso order. And I think that may just be me calling it a Vasso order. And I think it's actually a misnaming because it actually comes from a case which was about an order by the arbitrators rather than the court. But I'll continue using it because I can't kick a bad habit. So in fact, we're looking here at an order under section 44(2)(b), preservation of evidence, or C, the inspection of evidence. And in those sorts of situations, we get into the restrictions that Karen was looking at earlier. So we get into subsection 3, is the case one of urgency, and is the order one for the purpose of preserving evidence or assets. And subsection 5, has the tribunal been, if the tribunal has not been appointed, of course, the point is that there's no power to act effectively, that they don't have power or they're unable for the time being to act effectively. So in short, the lack of overlap between section 38 and 44 applies because 44 is dealing with a situation where there is no tribunal, and it's so urgent that you can't get one constituted in order to try and get the section 38 process going, hence the lack of tension. So also, we looked earlier, and as Andrew's been explaining to us, we can also get an interim injunction under section 44(2)(e). And that actually goes, in theory, beyond freezing injunctions and search orders. And the high watermark, I suppose, of that jurisdiction, as Carolyn and Andrew were explaining, is Settlem and Roust, a strange case about the sale of a subject of an interest in a company, and an order was required to force one of the parties to make an application to the Russian Central Bank. And it's a long judgment, but the key point that arises out of it is that for the purposes of that of this jurisdiction of 44.3, a contractual right stands as an asset for the purposes of the subsection. And that's what justified the grant of an injunction under section 44 in that particular case. But it causes some disquiet, as we'll see later in the seminar. So things you can't do with section 44. Well, the first thing to bear in mind is that the power we've been looking at in section 44.2e is to grant an interim injunction, not a final injunction. And the rationale there, of course, is that the tribunal will have the power to make a final injunction, albeit without the court's coercive powers. Just a note to myself here, I always call this sort of application an application for an award, a partial award for hire, an interim award, but of course it's not interim, it's actually dispositive of the right to receive the hire. But the point is that the tribunal then they can make a final injunction, but they can't make an interim injunction unless the parties have given them that power to make provisional awards, and that hence the limitation there that you can see in section 44.2. So I talked earlier about some disquiet about Settlem. Well, that's because it lies right on the borderline between the powers of the arbitrator, the jurisdiction of the arbitrator, to decide the very thing that's in dispute, and the court's power to make an order in support of the arbitral process. So there's a long line of cases, a depressingly long line of cases when I set out to read them on Easter Monday, which attempt to limit the jurisdiction in Settlem, or rather in which the court has declined to exercise its powers to make an order to preserve a contractual right in this way. So just some examples. Zim versus European Container, and a decision of this Justice Mayles. It's a complicated case in which the claimant was the seller of the vessel under a ship sale and purchase, but he was also going to be the charter. It was a sale and charter back. And but to make things even more difficult, he was actually loaning some of the money to the buyer to buy the ship as well. And what he was worried about was that if the charter party, if the owners, the buyers, ended up withdrawing the vessel under the charter party for a deduction from hire, he wouldn't get paid his loan. So what he did is he sought an injunction from the court to stop the vessel being withdrawn. But that caused Mr. Justice Mayles some disquiet, some queasiness, simply because although the argument was that all the court needed to do was decide whether there was a good arguable case, it came really very close to asking them to decide they can't withdraw the vessel. And so in the exercise of the discretion, for some other reasons, the application was declined. And a more recent case, JOL JPM, pretty similar, really. That was a bareboat charter case. The owner under the bareboat charter said that he had terminated the charter party and was entitled to repossess the vessels. And the charterer disputed the termination. He disputed the validity of the notice. Owner goes to court to try and get an order under section 44 for the delivery up of the ships, an injunction. And Mr. Justice Foxton declines to give it, again, for much the same reasons that Mr. Justice Mayles gave in Zim. It was the disquiet about trespassing on the tribunal's jurisdiction to make a dispositive award. So those are ordinary injunctions of various different kinds. Anti-suit injunctions. We'll all be familiar with this case. It's the case that has launched 1,000 mispronunciations, including mine. Kamenogorsk, I think, is the closest I've got to it, but I'm probably wrong about that. That went all the way to the Supreme Court. And Lord Mance decided that the jurisdiction to give an anti-suit injunction lies purely under section 37 of the Senior Courts Act, not under section 44, regardless of whether you're going for an interim injunction or a final injunction, and regardless of whether or not there's an arbitration on foot. And what the rationale for that is that the anti-suit injunction is enforcing the negative promise not to sue other than in arbitration. And what Lord Mount said this is, in those circumstances, it's not really for the purposes of and in relation to arbitral proceedings, because there was no intention to commence arbitral proceedings there. All that the claimant wanted to do was to enforce the negative obligation not to sue them other than in London arbitration. Notably, and we'll come back to this in just a moment, you can still use an arbitration claim form for your application under Section 37, and you can still use Part 62.5 as the basis for serving out. But we'll come back to that again in a moment. So, other things you can't do with Section 44, third parties. First of all, what do we mean by a third party? Well, we don't mean a party claiming through one of the parties to the arbitration. So like the classic example is a subrogated underwriter. They launch proceedings, substantive proceedings in China because they say that they're not bound by the arbitration clause in the Bill of Lading, but of course they're claiming through a party to the Bill of Lading, and so they have to sue in London arbitration. That's the J. Bowler, and also Mr. Justice Cook's decision in Starlighting Taiping. But at the moment, Richard talked about this earlier, the Chabra order. At the moment, you can't get a Chabra order against, against, for example, a subsidiary of your award debtor, because the jurisdiction, so it was said in Crew City and Unitech, I think another decision of Mr. Justice Mayers, that doesn't extend to an order against third parties. And similarly, an order against a third party for the preservation and inspection of evidence, that can't be made against under Section 44 either. Ditek and Morozov, a decision of Mrs. Justice Cockrell, that was a Ukrainian inspection agency, and they had evidence in hand, and they had made a determination for the purposes of a contract. The idea was to get their hands, to get the parties' hands on that evidence outside of the court's jurisdiction. And actually, there's no power on the law as it stands to allow service of an arbitration claim form on a third party outside of the jurisdiction, no long-arm jurisdiction, under 62.5, 1B or C, Varley and Bastille, and other decisions, which we'll come to in just a second. Maybe that's changing already. A recent decision about by the Court of Appeal, A versus C, strange sort of case, because it's one of those that builds on the point that Karen made earlier. Section 44, one of the unusual sections in the Arbitration Act that can be used in support of arbitration proceedings whose seat is not in England or Wales. So in A versus C, New York arbitration, witness in London, they come to London to try and get an order to take the evidence from the witness under Section 44.2. And that's granted by the Court of Appeal, but they don't. They purposefully don't speak about any of the other limbs of the relief under Section 44.2. They leave that question open, although there may be some skepticism in the judgment, an undertone of skepticism. That brings us neatly segueing into things you might be able to do with Section 44 in the future. I think we all know this, and actually I think Professor Green gave a speech on this at the LMAA dinner. The Law Commission's report, recommendation number 8, after taking soundings from many people, including I think the judges of the Commercial Court and the LMAA, we recommend that Section 44 of the Arbitration Act be amended to confirm that that court orders thereunder can be made against third parties. The proposal is to amend the Act so that Section 44.1 will be amended in such a way as to so that it's made clear that you can apply for an injunction against a non-party. So the exact wording is going to be in subsection 1, after making orders, insert whether in relation to a party or any other person. Now, presently, that bill is at the report stage, I believe, in the House of Lords. Whether or not it makes it over the finishing line before a democratic event that may or may not take place later in the year, it's quite another matter. Now, will any of that actually be relevant to our practices in shipping? Well, maybe. let's say that your subcharterer wants a Vasso order. He wants to inspect the chartered vessel, but he doesn't actually have a charter party directly with the owner. He has a charter party with a disponent owner. Maybe he wants to leapfrog and get the order directly against the owners. Or maybe the Chabra jurisdiction that Richard spoke about. Maybe he'll be wanting to obtain that sort of relief in aid of arbitration. And no doubt the law is going to have to develop as regards the exercise of the court's discretion in those circumstances when it comes to orders against third parties. But the real question that arose in my mind is how exactly jurisdiction will work, because of course in our world it would be extremely difficult, extremely unusual to have an application against a party or indeed an asset which is located within the jurisdiction. It's always long-arm jurisdiction. So how do you get in those circumstances leave to serve out? Where does that come from? So 62.5, just to show you the part as it stands, subject to paragraph 2A, and that's a paragraph dealing with situations where you don't need permission to serve out. The court may give permission to serve an arbitration claim form out of the jurisdiction if the claim is for an order under section 44 of the Act, or, more complicated, the claimant seeks some other remedy or requires a question to be decided by the court affecting an arbitration agreement or arbitration award, and the seat of the arbitration is or will be within the jurisdiction of the conditions of section 2.4 are satisfied. So those are the two limbs we're really talking about here. So you amend section 44 so as to give a power to make an order against a third party. Where's your jurisdiction coming from? White Book, the present edition, comments quite trenchantly that there is no power to permit service out on a third party under section 62.51c. And that's the Bowell Steel case and the other cases we looked at a little earlier. But what about 62.51b? The claim is for an order under section 44 of the Act. Well, that limb failed in the cases we looked at earlier, like JOL and its predecessor, simply because there is no power to make an order against a third party under section 44, ergo section 62.51b does not apply. There were strong objections, though, in principle, to making an order and exercising long-arm jurisdiction in those cases. And one can see why. One can see a whole range of situations. It's one thing to have a chain of charter parties, A, B, C, C being the subcharterer. C wants to get on board the vessel. You've got London arbitration clause in the subcharter and in the head charter. It's a matter of pure chance that it's C making the application rather than B. B could make the same application as C if it wanted to. That might be perhaps a suitable case for the exercise of the discretion if section 44 is broadened in the way that the bill proposes. But it'd be quite another in a sort of DTEC situation. You've got an inspection agency in Ukraine. You want to look at what they've got. How are you invoking the court's jurisdiction in that case? It may be appropriate, it may be inappropriate, but the law will no doubt require some development there. So I think that when they took soundings about amending section 44, there was one case, I think from 20 Essex called 20 Essex Street, and there was a suggestion that this would be the gateway, but obviously the amendment of section 44 would have to be held to carry with it a sort of sotto voce amendment of 62.51b. Maybe, or maybe it will need to be amended. But that's all from me. Thank you very much indeed.
Right, so who's going to be brave enough to put their hand up and ask the first question? We all just want to drink.
Someone's got to ask a question. Last two freezes I've done were incredibly frustrating because I didn't catch anything on either of them. And you did all the work. You'd have thought that you'd had some success with it. And on both those examples, I just would have wished that there was a Chabra jurisdiction available. So, because you felt that the money must be somewhere, but just not with the counterparty to the arbitration. And I just wondered, have you got any potential solutions to that problem at the moment before we can extend Section 44 against third parties?
Well, Chabras are regularly granted in court outside the arbitration context, but the problem is you have to know who the third party is that you want to target, and you have to have a so you basically you have to know where the money is.
But that, I mean, one thing that can be helpful in that regard is the ancillary disclosure requirements that often come with a freezer. So it may be that in the first instance, you don't end up catching what you're looking for, but that the information that you get gives you enough to start digging and finding out where the assets really are, if there are some.
Yes, but you have to move fast.
Is it me? Andrew, you were saying, do I need this? You were saying in the context of talking about freezing orders, you were saying a situation where you can't arrest a ship and you can't get club security, almost suggesting that the freezer is an alternative form of security. This is a very pedantic point, but it's not security, as you know. I mean, I just wanted to get that on the record. This is what we teach our youngsters all the time, is the freezer is not security. It may help you with security, and it avoids assets being dissipated, but it is not an equivalent of a club letter, having arrested the ship or a fund in the court. Just the pedantic side of me just wanted to get that out there.
Yeah, you're quite right. I suppose I probably should have said that it's an alternative.
And I suppose the problem is that if you do identify assets, then it's often against someone who owes money left, right, and centre, and a whole load of other creditors come piling in. Yeah.
I didn't know the case about the Iraqi surveyors who had the evidence, but it occurred to me to think, well, if they were in this country, you could presumably get a subpoena against them, requiring them to produce the evidence to the tribunal. Now, if they're not in this country, could you not get some sort of letter of request to the court where they are?
So you were thinking of a request for a letter of rogatory, what that used to be, that process, in aid of arbitration. That power presumably would lie under Section 44(2) again. So you would still need to apply to the court. But of course, if you had a party within the jurisdiction, that may be, you may fall then into a sort of like the A versus C case that we mentioned earlier, where they said, well, we don't think this applies. The restriction against third party applies when we're taking evidence from a witness within the jurisdiction for the purposes of a New York arbitration. It'd be hard to see why the answer would be different if you have a domestic arbitration. Yes, if we're talking about obtaining an order from somebody in Ukraine, though, one would still need to be able to put oneself within the section. Perhaps then, in those circumstances, there wouldn't be an objection because you were using the sort of power that the court exercised in A versus C that can act against third parties, because after all, otherwise the section wouldn't do any good. But you would still need to get leave to serve out, I suppose. So you would still need to persuade the court that you've got that power to serve the application on the respondent to the application.
Letters rogatory and the like are very cumbersome, and I say that because I was doing a case last month in which the key witness had moved to Italy and didn't want to come to London to give evidence in March when he could stay in the Italian Riviera. So the parties did get an order from the court here obliging him to give evidence to the court in Italy. And the Italian court was cooperative. All of this took weeks, if not months, of course. But when he was ordered by the Italian judge to come to court, he just didn't. The Italian judge kindly went to his house to interview him, and he then just refused to answer any of the questions. So the problem is, in other words, the machinery is cumbersome. I should add, this wasn't a question of getting documents out of him, it was getting him to be cross-examined. The parties had wanted to cross-examine him for a week. The judge in Italy relented to the extent of allowing each side to put 10 written questions to him in advance, which he didn't answer. But what this exemplifies, though, is that one of the problems about orders against third party in the arbitration context is that people overseas who can't be said to be committing a contempt of the order of the English court, so as to be punished by the English court, may simply choose not to obey any order that the English court makes. A party to the arbitration suffers peril if they don't comply with an order, because they may then lose the arbitration. A third party may feel differently. Someone who's a mere witness may simply not be engaged at all.
The answer is you have to go to the foreign court. It's as simple as that. If you want compulsion, you need to go to the foreign court. Often the arbitrator saying yes.
Absolutely. And the problem, of course, is that it can take a long time and that the attitudes to evidence overseas may be different from ours. But yes, you need to go to the place where someone can actually exercise power over the person in question.
Or the 25 or so volunteers who sit on the education subcommittee, and they put together these wonderful talks, and they work very hard and think very hard about what is topical. So thank you, Richard, for putting this one on, but also for the other contributors to our subcommittee. The second thanks, of course, goes to our panel here, and thank you very much indeed for going into that in such depth. I'm going to go off a little off-piste here in saying thank you, and just offer the view that in my view, the reason why London maritime arbitration is so successful is because of the relationship with the courts and the way that the courts back up the arbitrators by giving them, by making orders effective. So often, as a practitioner, you see that there is a potential for there to be for all your hard work to fall down without the support of the courts, and really they give backbone. So, Karen, you talked about emergency arbitrators. I don't think there's any appetite for that to come in London whatsoever. You were very diplomatic about that, but I just don't see it. And we've all got our own war stories, but if you are looking for some support for an action you've got, and you are on a Friday night, you're not going to muck around going to an emergency arbitration panel or whatever. You're going to go to Mr. Justice Bright. He's going to know exactly what you're talking about, and he's going to give you a remedy straight away. So that's my personal view. But anyway, thank you very much for going into it in such detail. And the last thanks is to 7KBW for sponsoring the drinks, which segues nicely into everyone, I hope, staying behind and enjoying a glass of wine. So thank you very much, everyone.